Thank you for all your comments, but I should advise you, I should be really careful. Simply because something sounds legal doesn't mean that it actually is. If you want to quote specific legal directives, then please quote them. But simply making broad statements is not going to convince me or indeed anybody else. Now, when it comes to asylum and to migration, the efforts of Suella Braverman to define something as illegal have not yet been proven or tested in court. As it is, saying that passing through a safe country and coming to the UK, saying that that is illegal, and that we have, and that an asylum seeker has a duty to apply for asylum in the first safe country that they come through, is not true. That is a reference to the Dublin III Protocol, the Dublin III Convention, which says that if you are arriving in Europe, you must claim asylum in the first European country. It's not entirely true even there, because there is a case in 2011 when the European Court of Human Rights upheld a case against Greece, and there have been instances of abuse in France. And there's also been an instance of a person who claimed asylum in one European country from another European country, a European citizen who claimed asylum in another country, in another European country. So there is the case law that makes it very clear that we must, even if we were following the Dublin Convention, that we must be very careful to allow for the possibility of individual cases to go beyond that convention. But that convention doesn't even hold now. We have left Europe at Brexit. We left the Dublin III Convention, so it no longer applies. There is no concept of applying for asylum in the first safe country that you come to. And more than that, a 1999 direction by Lord Simon Brown made it very clear that somebody who was travelling through a country, even a safe country, had about 70 days to do so. That is British case history. So all this trumping on about safe countries and about our duty to apply for asylum in the first safe country we come from, and how you couldn't possibly come through France without applying for asylum, and therefore you have no right to cross the channel. This is hokum. And it doesn't matter how often you recite it. It doesn't matter how often you claim that Suella Braverman has said it. Suella Braverman knows better. She herself was an immigration lawyer. She knows her case history, and she knows these cases. And therefore she is simply bluffing. And she has set up a plan which is going to trap asylum seekers simply because they're not going to be able to get a judgment from a court, because those judgments from courts, those judgments from judges will have to be heard by ministers, and ministers will be too busy doing other things. So there will be a backlog of unheard issues, and in the meantime, those Rwanda flights will have taken place. We will subsequently, probably in the next parliament, be inundated by extraordinary legislation, because, of course, we will be in a mess. We won't be able to repatriate these refugees, these migrants from Rwanda to where? They don't want to go back to their own country, to their home country, so where shall we repatriate them? They didn't actually enter Britain legally, so we can't take them back into the UK. This is the interesting position that Suella Braverman is trying to get us into. What she is doing is setting up a hornet's nest of legal complexity. And I would not like to be in a position where I've got to unravel that. As for the European Court of Human Rights, that's nothing to do with Europe. That's something that was set up in the aftermath of World War II, and very much on the initiative of Winston Churchill. So, although it has the name Europe in it, it's not part of the European Union, and it's not something that we left when we effected Brexit. And I know I keep going on about this, but it's so tiresome to have these comments which are so gnomic, but so utterly without substance. So please, if you want to, if you have legal knowledge and you can quote the specific laws and the specific references, please do so, that support this extraordinary ideological position of Suella Braverman's and some of the cronies in the Home Office. I would love to know how they get round the 99 directive by Lord Simon Brown, how they get round the Article 38 of the 1951 Refugee Convention, which says that Article 31, which says that you cannot be penalised for the way in which you arrive in a country, so you can't arrive in a country illegally. So, although it's possible for Suella Braverman to make it clear that crossing the channel is an illegal act, is a criminal act, the moment somebody applies for asylum on this side of the channel, they should be heard. As indeed Suella Braverman made perfectly clear herself on the 22nd of November at a committee hearing when she was questioned by Tim Lawton, and she was questioned about a hypothetical African asylum seeker who had no safe and legal route through which to come to the UK, and in the UK he had relatives. How was he supposed to get to the UK? And Suella Braverman conceded that he might have to use a small boat, but that once he got to the UK, he should make an asylum request immediately. That, in fact, is the rule, that on the first opportunity, you make an asylum request at the country where you have arrived. How you get there, under Article 31, under the 1951 Refugee Convention, doesn't matter. This is why I have been saying quite consistently that if we want to deal with the small boat crisis, then we have to deal with it in a united way, as a group of nations, as a world, in a global convention. Now, of course, given the fact that we have a major confrontation going on between Russia and Ukraine, we're unlikely to get the cooperation of Russia. But I think most other nations can get together internationally to thrash out the issue of what in today's world would constitute an authentic asylum seeker, and how can they be dealt with. For example, could we possibly find some sort of centralized system to deal with people so that poorer countries, for example, in Europe, because this is something that is a heinous consequence of the Dublin III Protocol, poorer countries in Europe, in the southern states in Europe, are unfairly swamped with asylum applications because so many migrants turn up on their shores because theirs is the first port of call. We need a global response to a global problem. I'm not saying the problem doesn't exist. I'm not saying that there might be issues for local communities receiving a large influx of migrants. I think there are. And we need to find ways in which we deal with this. But doing it unilaterally and turning vulnerable people into the enemy because we can't be bothered to deal with this problem in a grown-up, mature way, it's not the way forward. And I would have thought a government that has been in power for 13 years would have the knowledge, the links, and the capacity to call an international conference on this issue.